Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today. So today on the podcast, we have yet another Section 15 decision in our long line of Section 15 jurisprudence. I'm actually quite proud of the way we've been able to get a lot of these Section 15 decisions up because they tend to be very lengthy. Shout out again to the lovely people who guest read the really long ones for us. Today we have Law and Canada, which is probably the middle of the road in terms of the through line of Section 15 cases. It's not the most recent Section 15 case, but it is an interesting one. So did you read this one in Constitutional, Zach?
I'm sure I did. I remember in our discussions about this one is the one that deals with human dignity, yes, which is kind of like, I want to say like a splash on the discussion of Section 15, because correct me if I'm wrong, it's not that like human dignity isn't held up, but it's kind of been erased from Section 15, right?
Yes. So human dignity gets taken out of the Section 15 analysis with CAP, I believe. It's either CAP or NAP. I never remember, but from '08. So it's there for a while. It's there for like 15-ish years, but it does get removed because it was getting interpreted in sort of weird ways where now you had this sort of positive obligation to show that your dignity had been infringed on, which is hard because like dignity is kind of an elusive concept. So I think what had happened is just like the human dignity element wasn't doing what the court wanted it to do. And so they got rid of it because they found it was just sort of like an extra positive step when discrimination had occurred.
Yeah, that I can appreciate the court's reasoning for it. So it was kind of a splash, but I think that perhaps maybe leaves it open for it to be reconstructed again in the future, maybe under a different like framework or guide, because I think the discussion of human dignity, while albeit short, I think it does actually provide a lot of nuance to the Section 15 analysis. Because really, what are we talking about with Section 15? Like, what is the purpose of equality rights without having dignity?
No, I mean, Windsor has a whole class about it, which I took. We have a class called Human Dignity that Reem Badi teaches, and she is absolutely wonderful. And I took it and I loved it. And that was our whole semester, was really saying like, look, like we had this as part of our law for a little while. And what does that mean? Like, what does it mean to have a positive obligation on government action to give people dignity? Like that could mean many things, and it means different things to different people, and it means different things in different contexts. And even looking globally, you know, we checked out other statutes from other countries that had similar language, and no one's quite figured out what dignity means in the context of the law, because they're not two concepts that tend to mesh terribly well together, but they can, and like maybe they should, right? Like it's definitely sort of high level questions.
I think that's interesting too. Often sometimes this is kind of go down like a little personal philosophical diatribe, but I think one of the interesting things about law is we often look at these problems and we're like, they're so complicated, they're so difficult. But I don't know if it's Einstein or if it's some philosopher, but someone who is smarter than I am one time said, like, all human problems can be solved by ourselves because we made them up. So there's nothing that we can't fix by trying to fix it. I don't remember who it was, but I think that point should be more applicable to law, because I think a lot of the times people go, oh, human dignity, we can't figure it out, just never going to do it then. No, I think it's something that collectively we could figure out, and it's not going to be easy, but it is a problem of our own creation.
Yes. So, yeah, a couple things. One, I agree, but humans are just so good at making messes, and we're like 43% good at cleaning up the messes we make. But I don't think that means we shouldn't try. We should definitely be trying. And yeah, I think, and I mean, I do this too, certainly, because I think it's sort of an aspect of humanity. But having very nuanced, complicated conversations can be very uncomfortable. And I think which is totally natural, we do things that try to avoid uncomfortability, right? Because it's not fun to be uncomfortable. It's not a desired outcome. So rather than sort of have these conversations that get into things that may be very uncomfortable, we tend to just throw up our hands and say, welp, them's the breaks. And it's like, yeah, but it doesn't necessarily have to be that way if we sort of just do the super uncomfortable work of wading through these difficult and strange issues.
Mm-hmm.
But this is about midway in the sort of through line of Section 15 cases. It's not the most recent, but it definitely is amazing if you want to have any sort of discussion about what dignity means for the law, because this is when dignity was part of our law, was part of the constitutional line of cases under Section 15. So enjoy. Law and Canada, Minister of Employment and Immigration. Heard January 20th, 1998. Reheard December 3rd, 1998. Judgment March 25th, 1999. On appeal from the Federal Court of Appeal. The judgment of the court was delivered by Justice Iacobucci. Introduction and overview. This appeal concerns the constitutionality of Section 44(1)(d) and 58 of the Canada Pension Plan, which draw distinctions on the basis of age with regard to entitlement to survivors' pensions. The issue is whether the provisions infringe Section 15(1) of the Charter on the ground that they discriminate against persons under the age of 45 on the basis of age, and if so, whether the infringement is justified under Section 1 of the Charter. In my view, a purposive reading and application of Section 15(1) results in the conclusion that the appellant has not established discrimination within the meaning of the Charter. Section 15 of the Charter guarantees to every individual the right to equal treatment by the state without discrimination. It is perhaps the Charter's most conceptually difficult provision. In this court's first Section 15 case, Andrews and Law Society of BC, Justice McIntyre noted that, as embodied in Section 15(1) of the Charter, the concept of equality is an elusive concept, and that more than any of the other rights and freedoms guaranteed in the Charter, it lacks precise definition. Part of the difficulty in defining the concept of equality stems from its exalted status. The quest for equality expresses some of humanity's highest ideals and aspirations, which are by their nature abstract and subject to differing articulations. The challenge for the judiciary in interpreting and applying Section 15(1) of the Charter is to transform these ideals and aspirations into practice in a manner which is meaningful to Canadians and which accords with the purpose of the provision. In Andrews, Justice McIntyre, who delivered the unanimous reasons of the court on the issue of the proper approach to Section 15(1), cautioned that it would be inappropriate to attempt to confine analysis under Section 15(1) to a fixed and limited formula. This sentiment has been echoed in subsequent decisions. Justice McIntyre advocated a contextual and purposive approach to discrimination analysis under the Charter, and contrasted this preferred approach to the rigid formulation which had characterized this court's approach under the equality provision in the Canadian Bill of Rights. As he suggested, a flexible and nuanced analysis under Section 15(1) is preferable because it permits evolution and adaptation of equality analysis over time in order to accommodate new or different understandings of equality as well as new issues raised by varying fact situations. Such an approach also accords far better with the strong remedial purpose of Section 15, permitting the realization of that purpose. Indeed, in the brief history of this court's interpretation of Section 15(1) of the Charter, there have been several important substantive developments in equality law, relating to, among other things, the meaning of adverse effects discrimination, the role of context in identifying discrimination more generally, and the indicia of an analogous ground. All of these developments have been guided by the court's evolving understanding of the purpose of equality protection under Section 15(1). All have augmented and enriched anti-discrimination jurisprudence under the Charter. Throughout these developments, although there have been differences of opinion among the members of this court as to the appropriate interpretation of Section 15.1, I believe it is fair to say that there has been and continues to be general consensus regarding the basic principles relating to the purpose of Section 15.1 and the proper approach to equality analysis. In my view, the present case is a useful juncture at which to summarize and comment upon these basic principles in order to provide a set of guidelines for courts that are called upon to analyze a discrimination claim under the Charter. In accordance with Justice McIntyre's caution in Andrews, I think it is sensible to articulate the basic principles under Section 15.1 as guidelines for analysis and not as a rigid test which might risk being mechanically applied. Equality analysis under the Charter must be purposive and contextual. The guidelines which I review below are just that, points of reference which are designed to assist a court in identifying the relevant contextual factors in a particular discrimination claim and in evaluating the effect of those factors in light of the purpose of Section 15.1. The analysis in these reasons proceeds from the general to the more specific. I begin, after describing the background of the case, with a review of general principles regarding the proper approach to be followed in analyzing a discrimination claim. This portion of the reasons is concerned with outlining elements or stages of analysis whose content and application I then develop. The second portion of my analysis is a discussion of the basic principles which this court has articulated in past jurisprudence regarding the purpose of Section 15.1 and the fundamentally purposive nature of each stage of analysis under the provision. Next, on the basis of previous cases, I review some of the contextual factors which may assist a court in determining whether the purpose of Section 15.1 has been engaged within the context of a particular case. A summary of the elements of a discrimination claim, the purpose of Section 15.1, and the contextual factors then follows. Finally, I apply the principles articulated in this analysis to the case at bar. Part 2. Background. A. Legislation. The Canadian Pension Plan, CPP, is a compulsory social insurance scheme which was enacted in 1965 in order to provide contributors and their families with reasonable minimum levels of income upon the retirement, disability, or death of the wage earner. Among the benefits available under the CPP is the survivor's pension. This monthly benefit is paid to a surviving spouse whose deceased partner has made sufficient contributions to the CPP and who meets the eligibility criteria specified in 44(1)(d), namely an age threshold, responsibility for dependent children, or disability. A claimant who is over the age of 45 at the time of the contributor's death, or is maintaining dependent children of the deceased contributor, or is or becomes disabled, is entitled to receive the survivor's pension at the full rate. However, Section 58 gradually reduces that pension for able-bodied surviving spouses without dependent children who are between the ages of 35 and 45 by 1/120th of the full rate for each month that the claimant's age is less than 45 years at the time of the contributor's death. Pursuant to Section 44(1)(d), unless they should become disabled, able-bodied surviving spouses without dependent children who are under 35 at the time of death of the contributor are precluded from receiving a survivor's pension until they reach the age of 65. Part B. Facts. The appellant, Nancy Law, married Jason Law in 1980. Mr. Law died in 1991 at the age of 50, having contributed to the CPP for 22 years. At the time of his death, the appellant was 30 years old. Prior to Mr. Law's death, the couple had co-owned a small business. The appellant was responsible for the business operations, and her husband had the requisite technical knowledge and expertise. The business soon failed after Mr. Law's death. The appellant applied to receive survivor's benefits under the CPP. Her husband had made sufficient contributions under the CPP such that she would qualify for survivor benefits if she came within the class of persons entitled to receive them. However, her application was refused because she was under 35 years of age at the time of her husband's death, She was not disabled, and she did not have dependent children. The appellant appealed this decision to the Minister of National Health and Welfare, who rejected the appeal in May 1992. She then appealed to the Pension Plan Review Tribunal, arguing that the age distinctions in Section 44(1)(d) and 58 of the CPP discriminate against her on the basis of age, contrary to Section 15(1) of the Charter. The tribunal found that the legislation discriminates against those who, at the time of the contributor's death, have not reached age 35, have no dependent children, and are not disabled. However, the tribunal was unable to reach a consensus regarding Section 1 of the Charter. The majority concluded that the discrimination was justified under Section 1, and although a more precise test of need could have been crafted, the measures adopted were a reasonable attempt by Parliament to achieve the objective of the CPP. The dissenting member of the tribunal found the age distinctions in the impugned provisions were arbitrary, and that Parliament could have targeted needy dependents without discrimination by legislating a test to determine need. The appellant then appealed to the Pension Appeals Board, which, in a trial de novo, concluded that the impugned age distinctions did not violate the appellant's equality rights. The majority of the board also found that, even if the distinctions did infringe Section 15(1) of the Charter, they would be justified under Section 1. A subsequent appeal to the Federal Court of Appeal was dismissed, largely for the reasons of the Pension Appeals Board. Part 3. Relevant Statutory and Constitutional Provisions. Canada Pension Plan 44(1). Subject to this part, a survivor's pension shall be paid to the surviving spouse as determined pursuant to this Act of a deceased contributor who has made contributions for not less than the minimum qualifying period if the surviving spouse has reached 65 years of age or, in the case of a surviving spouse who has not reached 65 years of age, has at the time of death of the contributor reached 35 years of age, was at the time of death of the contributor a surviving spouse with dependent children, or is disabled. Section 58(1). Subject to this section, a survivor's pension payable to the surviving spouse of a contributor is a basic monthly amount as follows. A. In the case of a surviving spouse who has not reached 65 years of age and to whom no retirement pension is payable under this Act or a provincial pension plan, a basic monthly allowance consisting of 1. A flat rate benefit calculated as provided by subsection 1(1), and 2. 37.5% of the amount of the contributor's retirement pension, calculated as provided in sub 3. Reduced unless the surviving spouse was at the time of the death of the contributor a surviving spouse with dependent children, or unless he is disabled, by 1/120th for each month by which the age of the surviving spouse at the time of death of the contributor is less than 45 years, and reduced if at any time after the death of the contributor the surviving spouse ceases to be a surviving spouse with dependent children and is not at that time disabled, or disabled and is not at that time a surviving spouse with dependent children, by 1/120th each month by which the age of the surviving spouse at the time is less than 45 years. Canadian Charter of Rights and Freedoms 15(1). Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Part 4. Judicial History. A. Pension Appeals Board. Justices Rutherford and Duralt concurring. Following an extensive extract from the respondent's expert report, adduced at the trial de novo before the Pension Appeals Board, Justice Rutherford stated that although many laws create legal distinctions, not all amount to discrimination within the meaning of Section 15(1) of the Charter. He went on to find that although age is a factor in determining eligibility for survivors' benefits under CPP, it is not the sole criterion. Rather, it is a combination of age, healthful employability, and freedom from the responsibility of dependent children, which may lead to exclusion from benefits. Moreover, he held that to the extent that age is a factor in the denial of benefits, Section 44(1)(d)(2)(a) and 58 do not create the kind of distinction that has been characterized as discrimination in the constitutional sense. Justice Rutherford noted that the Supreme Court of Canada has used Section 15(1) of the Charter as a means of protecting discrete and insular minorities and of shielding vulnerable groups against stigmatization, stereotyping, and prejudice. Quoting with approval from the remarks of Justice Wilson and McKinney and University of Guelph, he found that none of the evidence in the present case suggested that the appellant is a member of a group that suffers discrimination in charter terms. Nor, he observed, did the evidence suggest that able-bodied and young surviving spouses without responsibility for children are treated differently on the basis of an irrelevant personal characteristic from those who do not receive survivors' pension benefits. Rather, Justice Rutherford found that age is a very relevant characteristic to be considered in determining relative need for survivors' benefits. He also noted that the appellant is not a member of a traditionally disadvantaged group, an insular minority, or a segment of society that is or may be stigmatized, stereotyped, or subjected to prejudice. Accordingly, he concluded that even though the impugned provision draws a distinction based on age, this does not constitute discrimination within the meaning of Section 15(1) of the Charter. Although it was not necessary to do so in order to dispose of the appeal, Justice Rutherford went on to find that even if the impugned provisions of the CPP did infringe Section 15(1) of the Charter, the infringement would be justified under Section 1 of the Charter. He acknowledged that the extension of benefits to widowers and the elimination of remarriage as a bar to continuing survivors' benefits had diluted the original legislative objective, making it difficult for Sections 44(1)(d)(2)(a) and 58 to pass the justificatory test under Section 1 of the Charter without being found vulnerable on one point or another. However, in his view, the complexity of the CPP, its status as an overarching federal-provincial benefits system, and its onerous amendment requirements justify deference to Parliament's choice of measures. Appeal Justice Angers. Appeal Justice Angers agreed with his colleagues' reasons regarding discrimination on the basis of age, but preferred not to comment on the effect of Section 1 of the Charter. Federal Court of Appeal. Chief Justice Isaac, delivering judgment on behalf of a unanimous court, was not convinced that the Pension Appeals Board had committed a reviewable error. He stated that the court substantially agreed with the reasons of the board that neither Section 44(1)(d) nor 58 of the CPP infringes upon the appellant's equality rights guaranteed by Section 15(1) of the Charter. The Court of Appeal was also in substantial agreement with the majority opinion that, even if those provisions do infringe Section 15(1) of the Charter, they constitute a reasonable limit under Section 1 of the Charter. Accordingly, the appeal was dismissed. Part 5. Issues. By order of the Chief Justice dated March 26, 1997, the following constitutional questions were stated for this court's consideration. 1. Does Section 44(1)(d) and 58 of the CPP infringe on Section 15(1) of the Charter on the ground that they discriminate against widows and widowers under the age of 45 on the basis of age? If so, can this infringement be demonstrably justified in a free and democratic society under Section 1 of the Charter? Part 6. Analysis. A. Approach to Section 15(1). Subsection 15(1) of the Charter states as follows: Every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. On its face, Section 15(1) guarantees the equal treatment of individuals by the state without discrimination. The concepts of equality and discrimination lie at the heart of the provision. What do these concepts mean and how are they to be established? An excellent starting point in answering these questions is the Andrews decision, which articulates many of the basic principles which continue to guide Section 15(1) analysis to the present day. Andrews Revisited. Justice McIntyre and Andrews adopted an approach to Section 15.1 which focuses upon three central elements. 1. Whether a law imposes differential treatment between the claimant and others. 2. Whether an enumerated or analogous ground of discrimination is the basis for the differential treatment. And 3. Whether the law in question has a discriminatory purpose or effect. In these reasons, for the sake of convenience, I will refer only to discriminatory laws, and not to the various other forms of potentially discriminatory state action. The first element, differential treatment, relates to, but is not determinative of, the issue of equality for the purpose of Section 15.1. The second and third elements in Justice McIntyre's approach determine whether the differential treatment in question constitutes discrimination within the meaning of Section 15.1 of the Charter. In his detailed discussion of these three elements, Justice McIntyre made clear that the analysis of each element is to be undertaken in a purposive and contextualized manner, taking into account the large remedial component of Section 15.1 and the purpose of the provision in fighting the evil of discrimination. Justice McIntyre began his discussion of the requirement of differential treatment by noting that equality is a comparative concept, the condition of which may only be attained or discerned by comparison with the condition of others in the social and political setting in which the question arises. It is impossible to evaluate a Section 15.1 claim without identifying specific personal characteristics or circumstances of the individual or group bringing the claim, and comparing the treatment of that person or group to the treatment accorded to a relevant comparator. This comparison determines whether the Section 15.1 claimant may be said to experience differential treatment, which is the first step in determining whether there is discriminatory inequality for the purpose of Section 15.1. At the same time, Justice McIntyre emphasized that true equality does not necessarily result from identical treatment. Formal distinctions in treatment will be necessary in some contexts in order to accommodate the differences between individuals and thus to produce equal treatment in a substantive sense. Correspondingly, a law which applies uniformly to all may still violate a claimant's equality rights. The main consideration, Justice McIntyre stated, must be the impact of the law upon the individual or group to whom it applies, as well as upon those whom it excludes from its application. He explained that the determination of the impact of legislation, by its nature, must be undertaken in a contextual manner, taking into account the content of the law, its purpose, and the characteristics and circumstances of the claimant, among other things. Hence, equality in Section 15 must be viewed as a substantive concept. Differential treatment, in a substantive sense, can be brought about earlier by a formal legislative distinction, or by a failure to take into account the underlying differences between individuals in society. Moving on to discuss the requirement that a Section 15.1 claimant show that a differential treatment is discriminatory in order to establish a charter violation, Justice McIntyre defined discrimination in the following terms. Quote, discrimination may be described as a distinction, whether intentional or not, but based on grounds relating to personal characteristics of the individual or group, which has the effect of imposing burdens, obligations, or disadvantages on such individual or group not imposed on others, or which withholds or limits access to opportunities, benefits, and advantages available to other members of society. Distinctions based on personal characteristics attributed to an individual solely on the basis of association with a group will rarely escape the charge of discrimination, while those based on an individual's merits and capacities will rarely be so classed. Importantly, Justice McIntyre explained that the determination of whether a distinction in treatment imposes a burden or withholds a benefit so as to constitute discrimination within the meaning of Section 15.1 is to be undertaken in a purposive way. As he stated, the words without discrimination require more than a mere finding of a distinction between the treatment of groups or individuals. Moreover, in assessing whether a complainant's rights have been infringed under Section 15.1, It is not enough to focus only on the alleged ground of discrimination and decide whether or not it is an enumerated or analogous ground. Rather, a role must be assigned to Section 15.1, which goes beyond the mere recognition of a legal distinction on such a ground. The protection of equality rights is concerned with distinctions which are truly discriminatory. A discriminatory burden or denial of a benefit, Justice McIntyre stated, is to be understood in a substantive sense and in the context of the historical development of Canadian anti-discrimination law, notably human rights codes. The words without discrimination are a form of qualifier built into Section 15 itself and limit those distinctions which are forbidden by this section to those which involve prejudice or disadvantage. Further discussion of Justice McIntyre's statements regarding the purpose of Section 15.1 in remedying prejudice and disadvantage occurs below, where I discuss the purpose of Section 15.1 in more detail. At this point, it is sufficient to note that the court in Andrews held that the fact that a distinction is drawn on the basis of a ground expressly enumerated in 15.1 or more analogous thereto, although generally sufficient to establish discrimination, does not automatically give rise to this conclusion. In some circumstances, a distinction based upon an enumerated or analogous ground will not be discriminatory. As mentioned, Justice McIntyre in Andrews gave an indication as to one such type of permissible distinction, namely a distinction which takes into account the actual differences in characteristics or circumstances between individuals in a manner which respects the values, their dignity, and difference. As mentioned, Justice McIntyre in Andrews gave an indication as to one such type of permissible distinction, namely a distinction which takes into account the actual differences in characteristics or circumstances between individuals in a manner which respects and values their dignity and difference. Finally, regarding the role of the various grounds of discrimination expressly listed in Section 15.1, Justice McIntyre stated that they reflect the most common and probably the most socially destructive and historically practiced basis of discrimination, but noted that a Section 15.1 claim may also be brought on an analogous ground, in accordance with the provision's wording and with a proper interpretation of its remedial purpose. In her majority reasons elaborating on the specific issue of analogous grounds, Justice Wilson explained that a ground may qualify as analogous to those listed in Section 15.1 if persons characterized by the trait in question are, among other things, lacking in political power, vulnerable to having their interests overlooked and their rights to equal concern and respect violated, and vulnerable to becoming a disadvantaged group on the basis of that trait. Just as for the other two elements of the Section 15.1 analysis outlined by Justice McIntyre, Justice Wilson emphasized that the determination of whether a ground qualifies as analogous under Section 15.1 is to be undertaken in a contextual manner. Quote, "This is a determination which is not to be made only in the context of the law which is subject to challenge, but rather in the context of the place of the group in the entire social, political, and legal fabric of our society. While legislatures must inevitably draw distinctions among the governed, such distinctions should not bring about or reinforce the disadvantage of certain groups and individuals by denying them the rights freely accorded to others." In summary, then, the Andrews decision established that there are three key elements to a discrimination claim under Section 15.1 of the Charter: differential treatment, an enumerated or analogous ground, and discrimination in a substantive sense involving factors such as prejudice, stereotyping, and disadvantage. Of fundamental importance, as stressed repeatedly by all of the judges who wrote, the determination of whether each of these elements exists in a particular case is always to be undertaken in a purposive manner, taking into account the full social, political, and legal context of the claim. Post-Andrews jurisprudence. The general approach adopted in Andrews was regularly applied in subsequent decisions of the court. In Egan, Justice Corey, for himself and Justice Iacobucci, summarized the approach set out in Andrews as a two-step analysis with two components to the second step in the following terms. Quote, in Andrews and Turpin, a two-step analysis was formulated to determine whether a Section 15 right to equality had been violated. The first step is to determine whether, due to a distinction created by the questioned law, a claimant's right to equality before the law, equality under the law, equal protection of the law, or equal benefit of the law has been denied. During this first step, the inquiry should focus upon whether the challenged law has drawn a distinction between the claimant and others based on personal characteristics. Not every distinction created by legislation gives rise to discrimination. Therefore, the second step must be to determine whether the distinction created by the law results in discrimination. In order to make this determination, it is necessary to consider first whether the equality right was denied on the basis of a personal characteristic which is either enumerated in Section 15.1 or which is analogous to those enumerated, and second, whether that distinction has the effect on the claimant of imposing a burden, obligation, or disadvantage not imposed upon others, or of withholding or limiting access to benefits or advantages which are available to others. In Miron, Justice McLaughlin, with Justices Sapinka, Corey, and Iacobucci concurring, outlined a similar Section 15.1 framework as follows. Quote, the analysis under Section 15.1 involves two steps. First, the claimant must show a denial of equal protection or equal benefit of the law as compared with some other person. Second, the claimant must show that the denial constitutes discrimination. At this second stage, in order for discrimination to be made out, the claimant must show that the denial rests on one of the grounds enumerated in Section 15.1 or an analogous ground, and that the unequal treatment is based on the stereotypical application of presumed group or personal characteristics. If the claimant meets the onus under this analysis, violation of Section 15.1 is established. As was noted by Justice Iacobucci for the full court in Benner, the approaches adopted by Justice Corey in Egan and by Justice McLaughlin in Miron are essentially alike. Although Justice Corey did not, in the passage just quoted from the Egan decision, specifically advert to the role of factors such as stereotyping, prejudice, and historical disadvantage in the second step of the discrimination analysis, the remainder of the analysis in that case clearly reveals the fundamental importance of such factors, in accordance with the framework established in Andrews. Each of the elements of the approach to Section 15.1 articulated by the court in Andrews and confirmed in later cases has developed and been enriched by the subsequent jurisprudence. In Eaton, Justice Sapinka for the full court elaborated upon the point made by Justice McIntyre in Andrews that, although in many cases a claimant will be able to establish substantively differential treatment by pointing to a formal distinction drawn by the impugned legislation, there are other ways to establish differential treatment. In particular, Justice Sapinka noted that an approach which requires proof of an express legislative distinction is not necessarily applicable where a claim of adverse effects discrimination is made. In such cases, it is the legislation's failure to take into account the true characteristics of a disadvantaged person or group within Canadian society, i.e. by treating all persons in a formally identical manner, and not the express drawing of a distinction which triggers Section 15.1. Justice Sapinka's statements to this effect in Eaton were echoed in the subsequent cases of Eldridge and Vrienne, per Justices Corey and Iacobucci. In a similar vein, relating to the issue of enumerated and analogous grounds, the court has had the opportunity to develop the principles relating to the indicia of an analogous ground in such cases as Turpin, Miron, and Egan, among several others. Notably, in Symes, this court recognized that, although Andrews spoke of differential treatment being based upon one enumerated or analogous ground, it is open to a Section 15 claimant to articulate a discrimination claim on the basis of more than one ground. As discussed in more detail below, the claimant may place the evidentiary focus of the claim upon a person or subgroup identified by several grounds. In the same way, the jurisprudence of the court has affirmed and clarified Justice McIntyre's emphasis in Andrews upon the necessity of establishing discrimination in a substantive or purposive sense, beyond mere proof of a distinction on enumerated or analogous grounds. In Mirren, Justice McLaughlin confirmed that distinctions made on enumerated or analogous grounds may prove to be, upon examination, non-discriminatory. She explained that a distinction may be found not to engage the purpose of the Charter guarantee, or it may not have the effect of imposing a real disadvantage in the social and political context of the claim. In my view, the proper approach to analyzing a claim of discrimination under Section 15.1 of the Charter involves a synthesis of these various articulations. Following upon the analysis in Andrews and the two-step framework set out in Egan and Mirren, among other cases, a court that is called upon to determine a discrimination claim under Section 15.1 should make the following three broad inquiries. First, does the impugned law A. draw a formal distinction between the claimant and others on the basis of one or more personal characteristics? Or B. fail to take into account the claimant's already disadvantaged position within Canadian society, resulting in substantively differential treatment between the claimant and others on the basis of one or more personal characteristics? If so, there is differential treatment for the purpose of Section 15.1. Second, was the claimant subject to differential treatment on the basis of one or more of the enumerated and analogous grounds? And third, does the differential treatment discriminate in a substantive sense, bringing into play the purpose of Section 15.1 of the Charter in remedying such ills as prejudice, stereotyping, and historical disadvantage? The second and third inquiries are concerned with whether the differential treatment constitutes discrimination in the substantive sense intended by Section 15.1. Subpart B, the purpose of Section 15.1. As was emphasized in early Charter decisions such as Hunter and Southam and the Queen and Big M Drug Mart, and reiterated by Justice McIntyre in Andrews, the proper approach to the definition of rights guaranteed by the Charter is a purposive one. The purpose of Section 15.1 is to be sought, in the words of Justice Dixon as he then was in Big M Drug Mart, by reference to the character and the larger objects of the Charter itself, to the language chosen to articulate the specific right or freedom, to the historical origins of the concepts enshrined, and to the meaning and purpose of the other specific rights and freedoms with which it is associated within the text of the Charter. Since the beginning of its Section 15.1 jurisprudence, this Court has recognized that the existence of a conflict between an impugned law and the purpose of Section 15.1 is essential in order to found a discrimination claim. This principle holds true with respect to each element of a discrimination claim. The determination of whether legislation fails to take into account existing disadvantage, or whether a claimant falls within one or more of the enumerated and analogous grounds, or whether differential treatment may be said to constitute discrimination within the meaning of Section 15.1, must all be undertaken in a purposive and contextual manner. What is the purpose of the Section 15.1 equality guarantee? There is great continuity in the jurisprudence of this court on this issue. In Andrews, all judges who wrote advanced largely the same claim. Justice McIntyre stated that the purpose of Section 15 is to promote a society in which all are secure in the knowledge that they are recognized at law as human beings, equally deserving of concern, respect, and consideration. The provision is a guarantee against the evil of oppression, he explained, designed to remedy the imposition of unfair limitations upon opportunities, particularly for those persons or groups who have been subject to historical disadvantage, prejudice, and stereotyping. Similarly, Justice Laforêt, concurring with respect to the proper approach to Section 15.1, stated that the equality guarantee was designed to prevent the imposition of differential treatment that was likely to inhibit the sense of those who are discriminated against that the Canadian society is not free or democratic as far as they are concerned, and that it was likely to decrease their confidence that they can freely and without obstruction by the state pursue their and their families' hopes and expectations of vocational and personal development. As discussed above, Justice Wilson focused upon issues of powerlessness and vulnerability within Canadian society and emphasized the importance of examining the surrounding social, political, and legal context in order to determine whether discrimination exists within the meaning of Section 15.1. The principles expressed in Andrews were echoed in subsequent cases, dealing with all three primary examples of the discrimination analysis. For example, Justice Wilson, writing for a unanimous court in Turpin, engaged in a purposive analysis of Section 15.1 in order to determine whether it was appropriate to consider province of residence as an analogous ground of discrimination in the circumstances of the particular case. The appellants in that case, both charged with murder in Ontario, argued that they were denied their right to equal treatment because, unlike persons accused of murder in Alberta, they were denied the right to elect to be tried by a judge alone, without a jury. Justice Wilson stated that some of the central indicia of discrimination within the meaning of Section 15.1 were stereotyping, historical disadvantage, and vulnerability to political and social prejudice. Finding that no such indicia were present, Justice Wilson dismissed the appeal, stating, differentiating for mode of trial purposes between those accused of Section 427 offences in Alberta and those accused of the same offences elsewhere in Canada would not, in my view, advance the purposes of Section 15 in remedying or preventing discrimination against groups suffering social, political, and legal disadvantage in our society. A similar purposive approach was applied by Justice Laforêt, writing for a unanimous court in Weatherall, dealing with the question of whether a formal distinction in treatment on an enumerated ground could be said to qualify as discrimination within the meaning of the Charter. The appellant, a male inmate at a federal penitentiary, challenged the practices of frisk searching and patrolling of cell ranges by female guards as a violation of his right to equal treatment on the basis of sex under Section 15.1 of the Charter. In suggesting that these practices did not violate Section 15.1, Justice Laforêt explained that an examination of the larger historical, biological, and sociological context made clear that the practices in question had a different, more threatening impact on women, such that it was not discriminatory in a substantive or purposive sense to treat men and women differently in this regard. Similarly, in Eaton, Justice Sapinka applied a purposive approach to the determination of whether the state's failure to take into account the underlying difference of the disabled qualified as differential treatment or inequality within the meaning of Section 15.1. Justice Sapinka stated that in light of the underlying context surrounding disabled persons in Canadian society, avoidance of discrimination on the ground of disability would frequently require formal distinctions in treatment to be made in order to effect substantive equality. He explained that this emphasizes that the purpose of Section 15.1 of the Charter is not only to prevent discrimination by the attribution of stereotypical characteristics to individuals, but also to ameliorate the position of groups within Canadian society who have suffered disadvantage by exclusion from mainstream society, as has been the case with disabled persons. The purpose of Section 15.1 has been variously expressed by the members of this court. In McKinney, Justice Wilson, writing in dissent, described the purpose of the section as both protection against the evil of discrimination by the state, whatever form it takes, and the promotion of human dignity. In Swain, Chief Justice Lamel stated that the overall purpose of this section is to remedy or prevent discrimination against groups subject to stereotyping, historical disadvantage, and political and social prejudice in Canadian society. In Tetro Gaduri, Justice Laforêt referred to the stigmatizing effect of discriminatory treatment and to the role of Section 15.1 in preventing the imposition of such stigma and the perpetuation of negative stereotypes and vulnerability. Similar observations were made in Mirren and in Egan by Justices Leray-Dubé and Corey, all of whom found that the fundamental purpose of Section 15.1 is the protection of human dignity, Justice Corey stated in Egan that the equality guarantee recognizes and cherishes the innate human dignity of every individual. As he explained, the existence of discrimination is determined by assessing the prejudicial effect of the distinction against Section 15.1's fundamental purpose of preventing the infringement of essential human dignity. Similarly, in Mirren, Justice McLaughlin stated the overarching purpose of Section 15.1 as being to prevent the violation of human dignity and freedom by imposing limitations, disadvantages, or burdens through the stereotypical application of presumed group characteristics rather than on the basis of merit, capacity, or circumstance. In Egan, Justice Leray-Dubé stated in a similar vein, "At the heart of Section 15 is the promotion of a society in which all are secure in the knowledge that they are recognized at law as equal human beings, equally capable, and equally deserving. A person or group of persons has been discriminated against within the meaning of Section 15 of the Charter when members of that group have been made to feel, by virtue of the impugned legislative distinction, that they are less capable or less worthy of recognition or value as human beings or as members of Canadian society, equally deserving of concern, respect, and consideration." Most recently, in Vrian, Justices Corey and Iacobucci stated the purpose of Section 15.1 as being to take a further step in the recognition of the fundamental importance and the innate dignity of the individual, and in the recognition of the intrinsic worthiness and importance of every individual, regardless of the age, sex, color, origin, or other characteristics of the person. All of these statements share several key elements. It may be said that the purpose of Section 15.1 is to prevent the violation of essential human dignity and freedom through the imposition of disadvantage, stereotyping, or political or social prejudice, and to promote a society in which all persons enjoy equal recognition at law as human beings or as members of Canadian society, equally capable and equally deserving of concern, respect, and consideration. Legislation which affects differential treatment between individuals or groups will violate this fundamental purpose, where those who are subject to differential treatment fall within one or more enumerated or analogous grounds, and where the differential treatment reflects the stereotypical application of presumed group or personal characteristics, or otherwise has the effect of perpetuating or promoting the view that the individual is less capable or less worthy of recognition or value as a human being or as a member of Canadian society. Alternatively, differential treatment will not likely constitute discrimination within the purpose of Section 15.1, where it does not violate the human dignity or freedom of a person or group in this way, and in particular, where the differential treatment also assists in ameliorating the position of the disadvantaged within Canadian society. As noted above, one of the difficulties in defining the concepts of equality and discrimination is the abstract nature of the words and the similarly abstract nature of the words used to explain them. No single word or phrase can fully describe the content and purpose of Section 15.1. However, in the articulation of the purpose of Section 15.1, just provided on the basis of past cases, a focus is quite properly placed upon the goal of assuring human dignity by the remedying of discriminatory treatment. What is human dignity? There can be different conceptions of what human dignity means. For the purpose of analysis under Section 15.1 of the Charter, however, the jurisprudence of this court reflects a specific, albeit non-exhaustive, definition. As noted by Chief Justice Lamer and Rodriguez in British Columbia AG, the equality guarantee in Section 15.1 is concerned with the realization of personal autonomy and self-determination. Human dignity means that an individual or group feels self-respect and self-worth. It is concerned with physical and psychological integrity and empowerment. Human dignity is harmed by unfair treatment premised upon personal traits or characteristics which do not relate to individual needs, capacities, or merits. It is enhanced by laws which are sensitive to the needs, capacities, and merits of different individuals, taking into account the context underlying their differences. Human dignity is harmed when individuals and groups are marginalized, ignored, or devalued, and is enhanced when laws recognize the full place of all individuals and groups within Canadian society. Human dignity within the meaning of the equality guarantee does not relate to the status or position of an individual in society per se, but rather concerns the manner in which a person legitimately feels when confronted with a particular law. Does the law treat him or her unfairly, taking into account all of the circumstances regarding the individuals affected and excluded by the law? The equality guarantee in Section 15.1 of the Charter must be understood and applied in light of the above understanding of its purpose. The overriding concern with protecting and promoting human dignity in the sense just described infuses all elements of the discrimination analysis. In order to determine whether the fundamental purpose of Section 15.1 is brought into play in a particular claim, it is essential to engage in a comparative analysis which takes into consideration the surrounding context of the claim and the claimant. I now propose to comment briefly on the nature of the comparative approach, and then to examine some of the contextual factors that a court should consider in determining whether Section 15.1 has been infringed. Each factor may be more or less relevant depending on the circumstances of the case. Subpart C. The comparative approach. As discussed above, Justice McIntyre emphasized in Andrews that the equality guarantee is a comparative concept. Ultimately, a court must identify differential treatment as compared to one or more other persons or groups. Locating the appropriate comparator is necessary in identifying differential treatment and the grounds of the distinction. Identifying the appropriate comparator will be relevant when considering many of the contextual factors in the discrimination analysis. To locate the appropriate comparator, we must consider a variety of factors, including the subject matter of the legislation. The object of a Section 15.1 analysis is not to determine equality in the abstract. It is to determine whether the impugned legislation creates differential treatment between the claimant and others on the basis of enumerated or analogous grounds, which results in discrimination. Both the purpose and the effect of the legislation must be considered in determining the appropriate comparison group or groups. Other contextual factors may also be relevant. The biological, historical, and sociological similarities or dissimilarities may be relevant in establishing the relevant comparator, in particular, and whether the legislation affects discrimination in a substantive sense more generally. When identifying the relevant comparator, the natural starting point is to consider the claimant's view. It is the claimant who generally chooses the person, group, or groups with whom he or she wishes to be compared for the purpose of the discrimination inquiry, thus setting the parameters of the alleged differential treatment that he or she wishes to challenge. However, the claimant's characterization of the comparison may not always be sufficient. It may be that the differential treatment is not between the groups identified by the claimant, but rather between other groups. Clearly, a court cannot, ex proprio motu, evaluate a ground of discrimination not pleaded by the parties and in relation to which no evidence has been adduced. However, with the scope of the ground or grounds pleaded, I would not close the door on the power of a court to refine the comparison presented by the claimant where warranted. Subpart D. Establishing discrimination in a purposive sense, contextual factors. The appropriate perspective. The determination of the appropriate comparator and the evaluation of the contextual factors which determine whether legislation has the effect of demeaning a claimant's dignity must be conducted from the perspective of the claimant. As applied in practice in several of this court's equality decisions, and as neatly discussed by Justice Leray-Dubé and Egan, the focus of the discrimination inquiry is both subjective and objective. Subjective insofar as the right to equal treatment is an individual right, asserted by a specific claimant with particular traits and circumstances, and objective insofar as it is possible to determine whether the individual claimant's equality rights have been infringed only by considering the larger context of the legislation in question, and society's past and present treatment of the claimant and of other persons or groups with similar characteristics or circumstances. The objective component means that it is not sufficient, in order to ground a Section 15.1 claim, for a claimant simply to assert, without more, that his or her dignity has been adversely affected by law. As stated by Justice Leray-Dubé and Egan, the relevant point of view is that of the reasonable person, dispassionate and fully apprised of the circumstances, possessed of similar attributes to, and under similar circumstances as, the claimant. Although I stress that the inquiry into whether legislation demeans the claimant's dignity must be undertaken from the perspective of the claimant and from no other perspective, a court must be satisfied that the claimant's assertion that differential treatment imposed by legislation demeans his or her dignity is supported by an objective assessment of the legislation. All of that individual or that group's traits, history, and circumstances must be considered in evaluating whether a reasonable person in circumstances similar to those of the claimant would find that the legislation which imposes differential treatment has the effect of demeaning his or her dignity. I should like to emphasize that I in no way endorse or contemplate an application of the above perspective, which would have the effect of subverting the purpose of Section 15.1. I am aware of the controversy that exists regarding the biases implicit in some applications of the reasonable person standard. It is essential to stress that the appropriate perspective is not solely that of a reasonable person, a perspective which could, through misapplication, serve as a vehicle for the imposition of community prejudices. The appropriate perspective is subjective-objective. Equality analysis under the Charter is concerned with the perspective of a person in circumstances similar to those of the claimant, who is informed of and rationally takes into account the various contextual factors which determine whether an impugned law infringes human dignity as that concept is understood for the purposes of Section 15.1. Contextual factors. There is a variety of factors which may be referred to by a Section 15.1 claimant in order to demonstrate that legislation has the effect of demeaning his or her dignity, as dignity is understood for the purpose of the Charter Equality Guarantee. In these reasons, I discuss 4 such factors in particular, although as I discuss below, there are undoubtedly others and not all 4 factors will necessarily be relevant in every case. Pre-existing disadvantage. It has been consistently recognized throughout this court's jurisprudence, probably the most compelling factor favoring a conclusion that differential treatment imposed by legislation is truly discriminatory, will be where it exists, pre-existing disadvantage, vulnerability, stereotyping, or prejudice experienced by the individuals or group. These factors are relevant because, to the extent that the claimant is already subject to unfair circumstances or treatment in society by virtue of personal characteristics or circumstances, persons like him or her have often not been given equal concern, respect, and consideration. It is logical to conclude that, in most cases, further differential treatment will contribute to the perpetuation or promotion of their unfair social characterization and will have a more severe impact upon them since they are already vulnerable. One consideration which the court has frequently referred to with respect to the issue of pre-existing disadvantage is the role of stereotypes. A stereotype may be described as a misconception whereby a person, or more often, a group, is unfairly portrayed as possessing undesirable traits, or traits which the group, or at least some of the members, do not possess. In my view, probably the most prevalent reason that a given legislative provision may be found to infringe Section 15.1 is that it reflects and reinforces existing inaccurate understandings of the merits, capabilities, and worth of a particular person or group within Canadian society, resulting in further stigmatization of that person or the members of the group or otherwise in their unfair treatment. This view accords with the emphasis placed by this court, ever since Andrews, upon the role of Section 15.1 in overcoming prejudicial stereotypes in society. However, proof of the existence of a stereotype in society regarding a particular person or group is not an indispensable element of a successful claim under Section 15.1. Such a restriction would unduly constrain discrimination analysis when there is more than one way to demonstrate a violation of human dignity. I emphasize, then, that any demonstration by a claimant that a legislative provision or other state action has the effect of perpetuating or promoting the view that the individual is less capable or less worthy of recognition or value as a human being or as a member of Canadian society, whether or not it involves a demonstration that the provision or other state action corroborates or exacerbates an existing prejudicial stereotype, will suffice to establish an infringement of Section 15.1. It should be stressed that, while it is helpful to demonstrate the existence of historic disadvantage, it is of course not necessary to show such disadvantage in order to establish a Section 15.1 violation, for at least two distinct reasons. On the one hand, this court has stated several times that, although a distinction drawn on such a basis is an important indicium of discrimination, it is not determinative. A member of any of the more advantaged groups in society is clearly entitled to bring a Section 15.1 claim, which in appropriate cases will be successful. On the other hand, it may be misleading or inappropriate in some cases to speak about membership within a group for the purpose of a Section 15.1 claim. The Charter guarantees equality rights to individuals. In this respect, it must be made clear that the Section 15.1 claimant is not required to establish membership in a sociologically recognized group in order to be successful. It will always be helpful to the claimant to be able to identify a pattern of discrimination against a class of persons with traits similar to the claimant, i.e., a group of which the claimant may consider herself or himself a member. Nonetheless, an infringement of Section 15.1 may be established by other means and may exist even if there is no one similar to the claimant who is experiencing the same unfair treatment. At the same time, I also do not wish to suggest that the claimant's association with a group which has historically been more disadvantaged will be conclusive of a violation of Section 15.1, where differential treatment has been established. This may be the result, but whether or not it is the result will depend upon the circumstances of the case, and in particular, upon whether or not the distinction truly affects the dignity of the claimant. There is no principle or evidentiary presumption that differential treatment for historically disadvantaged persons is discriminatory. Moreover, in line with my earlier comment in referring to groups which, historically, have been more or less disadvantaged, I do not wish to imply the existence of a strict dichotomy of advantaged and disadvantaged groups within which each claimant must be classified. I mean to identify simply the social reality that a member of a group which historically has been more disadvantaged in Canadian society is less likely to have difficulty in demonstrating discrimination. Since Andrews, it has been recognized in the jurisprudence of this court that an important, though not exclusive purpose of Section 15.1 is the protection of individuals and groups who are vulnerable, disadvantaged, or members of discrete and insular minorities. The effects of a law as they relate to this purpose should always be a central consideration in the contextual 15.1 analysis. Relationship between grounds and the claimant's character or circumstances. What are some factors other than an individual or group's pre-existing disadvantage which may be referred to by a Section 15.1 claimant in order to demonstrate a negative effect upon the claimant's dignity? One factor in some circumstances may be the relationship between the ground upon which the claim is based and the nature of the differential treatment. Some of the enumerated and analogous grounds have the potential to correspond with need, capacity, or circumstances. As was recognized in Eaton and in Eldridge, one of these grounds is a disability, where the avoidance of discrimination will frequently require that distinctions be made to take into account the actual personal characteristics of disabled persons. Another ground is sex, as was recognized by this court in Weatherall, and in the context of a statutory human rights code in Brooks and Canada Safeway Limited. A further such ground is age, where need, capacity, or circumstances may again correspond with the ground. It is thus necessary to analyze in a purposive manner the ground upon which the Section 15.1 claim is based when determining whether discrimination has been established. As a general matter, as stated by Justice McIntyre in Andrews and by Justice Sapinka in Eaton, and referred to above, legislation which takes into account the actual needs, capacity, or circumstances of the claimant and others with similar traits in a manner that respects their value as human beings and members of Canadian society will be less likely to have a negative effect on human dignity. This is not to say that the mere fact of impugned legislations having to some degree taken into account the actual situation of persons like the claimant will be sufficient to defeat a Section 15.1 claim. The focus must always remain upon the central question of whether, viewed from the perspective of the claimant, the differential treatment imposed by the legislation has the effect of violating human dignity. The fact that the impugned legislation may achieve a valid social purpose for one group of individuals cannot function to deny an equality claim where the effects of the legislation upon another person or group conflict with the purpose of the Section 15.1 guarantee. In line with the reasons of Justice McIntyre and Justice Sapinka, I mean simply to state that it will be easier to establish discrimination to the extent that impugned legislation fails to take into account a claimant's actual situation, and more difficult to establish discrimination to the extent that legislation properly accommodates the claimant's needs, capacities, and circumstances. Examples are prevalent in the jurisprudence of this court of legislation or other state action which either failed to take into account the actual situation of the claimant, or alternatively quite properly treated a claimant differently on the basis of actual personal differences between individuals. In Eldridge, for example, a provincial government's failure to provide limited funding for sign language interpreters for deaf persons when receiving medical services was found to violate Section 15.1, in part on the basis that the government's failure to take into account the actual needs of deaf persons infringed their human dignity. Conversely, in Weatherall, it was stated that the decision to permit cross-gender prison searches of male prisoners, but not of female prisoners, likely did not violate Section 15.1, because such a difference in treatment was appropriate in light of the historical, biological, and sociological differences between men and women. Ameliorative purpose or effects. Another possibly important factor will be the ameliorative purpose or effects of impugned legislation or other state action upon a more disadvantaged person or group in society. As stated by Justice Sapinka and Eaton, the purpose of Section 15.1 of the Charter is not only to prevent discrimination by the attribution of stereotypical characteristics to individuals, but also to ameliorate the position of groups within Canadian society who have suffered disadvantage by exclusion from mainstream society. An ameliorative purpose or effect, which accords with the purpose of Section 15.1 of the Charter, will likely not violate the human dignity of more advantaged individuals, where the exclusion of these more advantaged individuals largely corresponds to the greater need or the different circumstances experienced by the disadvantaged group being targeted by the legislation. I emphasize that this factor will likely only be relevant where the person or group is excluded from the scope of ameliorative legislation or other state action is more advantaged in a relative sense. Under-inclusive ameliorative legislation that excludes from its scope the members of a historically disadvantaged group will rarely escape the charge of discrimination. At the same time, I would not wish to be taken as foreclosing the possibility that a member of society could be discriminated against by laws aimed at ameliorating the situation of others, requiring the court to consider justification under Section 1 or the operation of Section 15.2. The possibility of new forms of discrimination denying essential human worth cannot be foreclosed. That said, the ameliorative aim and effect of the law is a factor to be considered in determining whether discrimination is present. Conversely, where the impugned legislation does not have a purpose or effect which is ameliorative in Section 15.1 terms, this factor may be of some assistance, depending upon the circumstances, in establishing a Section 15.1 infringement. Nature of the interest affected. A further contextual factor which may be relevant in appropriate cases in determining whether the claimant's dignity has been violated will be the nature and scope of the interest affected by the legislation. This point was well explained by Justice Leray-Dubé in Egan. As she noted, if all other things are equal, the more severe and localized the consequences on the affected group, the more likely that the distinction responsible for these consequences is discriminatory within the meaning of Section 15 of the Charter. Justice Leray-Dubé explained that the discriminatory caliber of differential treatment cannot be fully appreciated without evaluating not only the economic but also the constitutional and societal significance attributed to the interest or interests adversely affected by the legislation in question. Moreover, it is relevant to consider whether the distinction restricts access to a fundamental social institution or affects a basic aspect of full membership in Canadian society, or constitutes a complete non-recognition of a particular group. There are other factors which may be referred to by a Section 15(1) claimant in order to establish an infringement of equality rights in a purposive sense, but they are not directly relevant to the inquiry in the present appeal. Guidance as to these other factors may be found in previous decisions of this Court and through analogy to the factors listed above. The general theme, though, may be simply stated. An infringement of Section 15(1) of the Charter exists if it can be demonstrated that, from the perspective of a reasonable person in circumstances similar to those of the claimant, who takes into account the contextual factors relevant to the claim, the legislative imposition of differential treatment has the effect of demeaning his or her dignity. Demonstrating the existence of discrimination in this purposive sense will require a claimant to advert to factors capable of supporting an inference that the purpose of Section 15(1) of the Charter has been infringed by the legislation. The nature and extent of the claimant's burden under Section 15(1). Having emphasized the importance of a claimant demonstrating that impugned legislation infringes Section 15(1) in a purposive sense, it will now be useful at this point to review the nature of the claimant's burden as a practical matter. There are 3 points which should be addressed. First, I should underline that none of the foregoing discussion implies that the claimant must adduce data or other social science evidence not generally available in order to show a violation of the claimant's dignity or freedom. Such materials may be adduced by the parties and may be of great assistance to a court in determining whether a claimant has demonstrated that the legislation in question is discriminatory. However, they are not required. A court may often, where appropriate, determine on the basis of judicial notice and logical reasoning alone whether the impugned legislation infringes Section 15(1). It is well established that a court may take judicial notice of notorious and undisputed facts, or of facts which are capable of immediate and accurate demonstration, by resorting to readily accessible sources of indisputable accuracy. There will frequently be instances in which a court may appropriately take judicial notice of some or all of the facts necessary to underpin a discrimination claim, and in which the court should engage in a process of logical reasoning from those facts to arrive at a finding that Section 15(1) has been infringed as a matter of law. I neither need nor wish to elaborate unduly in these reasons as to categories of facts which a court may properly take judicial notice for the purpose of a Section 15(1) claim. I would note, though, that this court has routinely and appropriately undertaken analysis under Section 15(1) on the basis of judicial notice and logical reasoning. To cite but one example, in Andrews, the issue of whether a citizenship requirement for entry into the legal profession in British Columbia infringed the right of non-citizens within Canada to equal treatment. Both the determination of whether citizenship constituted an analogous ground to those enumerated in Section 15(1) and the determination of whether the citizenship requirement imposed a truly discriminatory disadvantage were accomplished on the basis of judicial notice and logical reasoning by all the judges of this court who wrote. In deciding on the analogous ground issue, the court took judicial notice of the fact that relative to citizens, non-citizens are a group lacking in political power and as such vulnerable to having their interests overlooked and their rights to equal concern and respect violated. It was similarly found on the basis of reasoning alone that barring this vulnerable group from certain forms of employment solely on the basis of the personal characteristic of citizenship was a real disadvantage to the claimant, resulting in an infringement of Section 15.1. In making these observations regarding the use of judicial notice in equality analysis under the Charter, I should not be understood as expanding the range of facts of which it is appropriate to take judicial notice. The exercise of a certain amount of caution is in order in taking judicial notice. In particular, although it is clearly appropriate for the purpose of Section 15.1 to take judicial notice of certain forms of disadvantage and prejudice, among other things, one should not unwittingly or otherwise use judicial notice to invent stereotypes or other social phenomena which may not or do not truly exist. Second, it is equally important to emphasize that the requirement that a claimant establish a Section 15.1 infringement in this purposive sense does not entail a requirement that the claimant prove any matters which cannot reasonably be expected to be within his or her knowledge. As this court has previously stated, the Section 15.1 claimant is not required to establish that the intent of the legislature in enacting the impugned legislation was discriminatory, in the sense that, for example, the legislation was consciously premised upon a prejudicial stereotype, or the legislation purposely failed to take into account the social disadvantage of an individual or group in enacting the legislation. While it is well established that it is open to a Section 15.1 claimant to establish discrimination by demonstrating a discriminatory legislative purpose, proof of legislative intent is not required in order to found a Section 15.1 claim. What is required is that the claimant establish that either the purpose or the effect of the legislation infringes Section 15.1, such that the onus may be satisfied by showing only a discriminatory effect. There is nothing new in requiring a charter claimant to establish that his or her right has been infringed in a manner which brings into play the purpose of the right in question. Both the principle that charter rights are to be interpreted purposefully and the principle that the charter claimant bears the onus of establishing an infringement of his or her right before the onus shifts to the state to justify the infringement are fundamental and well established. In Andrews, Justice McIntyre specifically rejected an approach to analysis under Section 15.1, which would have seen the mere drawing of a legislative distinction as an infringement of the provision, noting that such a formalistic approach to the equality guarantee did not accord with its purpose. He also rejected an approach which would have seen issues of reasonableness and justification dealt with under Section 15 rather than under Section 1. In preferring the enumerated and analogous grounds approach to Section 15.1, Justice McIntyre emphasized that this approach struck the appropriate balance between the claimant and the state, stating that it must be admitted at once that the relationship between those two sections, Section 15 and Section 1, may well be difficult to determine on a wholly satisfactory basis. It is, however, important to keep them analytically distinct, if for no other reason than the different attribution of the burden of proof. It is for the citizen to establish that his or her charter right has been infringed, and for the state to justify the infringement. Third, it should be stressed that in some cases, it may not be necessary as a practical matter for a claimant to focus the purpose of analysis upon more than one element of the discrimination claim. For example, in cases where it is clear that a law draws a formal distinction upon enumerated or established analogous grounds, the issue in the case will largely be limited to that of whether the law discriminates in a sense which interferes with the claimant's dignity. Similarly, though the process of demonstrating that the adverse effect of a law is to produce substantive inequality through formal identical treatment, a claimant will often also make clear that the law infringes the human dignity of those affected, thus satisfying two elements of the Section 15.1 inquiry at once. Taking these 3 points into account, it should be clear that in some cases, it will be relatively easy for a claimant to establish a Section 15.1 infringement, while in other cases it will be more difficult to locate a violation of the purpose of the equality guarantee. In more straightforward cases, it will be clear to the court on the basis of judicial notice and logical reasoning that an impugned law interferes with human dignity and thus constitutes discrimination within the meaning of the Charter. Often, but not always, this will be the case where a law draws a formal distinction in treatment on the basis of enumerated or analogous grounds, because the use of these grounds frequently does not correlate with need, capacity, or merit. It may be sufficient for the court simply to take judicial notice of pre-existing disadvantage experienced by the claimant or by the group which the claimant is a member in order for such a Section 15.1 claim to be made out. In other cases, it will be necessary to refer to one or more other contextual factors. In every case, though, a court's central concern will be with whether a violation of human dignity has been established, in light of the historical, social, political, and legal context of the claim. In order to succeed under Section 15.1, it is up to the claimant to ensure that the court is made aware of this context in the appropriate manner. I should pause at this juncture to comment briefly upon an alternative method of articulating the approach to be taken under Section 15.1. I have reviewed in these reasons the general approach taken to Section 15.1 by this court, which involves three broad elements, namely 1. The existence of differential treatment, 2. The presence of enumerated or analogous grounds, and 3. The discrimination which brings into play the purpose of Section 15.1. However, it is possible to understand the third element of the Section 15.1 inquiry as really being a restatement of the requirement that there be substantive rather than merely formal inequality in order for an infringement of Section 15.1 to have been made out. Under this alternative view, the definition of substantive inequality is discrimination within the meaning of the Charter, bringing into play the claimant's human dignity. No substantive inequality would exist where the claimant's human dignity was not brought into play by his or her treatment by the state. I agree with the general idea that, in practice, in some cases, it may well be duplicative to determine first whether differential treatment exists, and then to determine whether the purpose of Section 15.1 has been brought into play. As I mentioned above, this will particularly be the case where adverse effects discrimination is at issue, since the analysis of whether the claimant's difference has been effectively ignored by an impugned law will usually bring into play issues of human dignity. In such cases, there may be no real difference in analysis or result regardless of whether one or the other approach is used. I do have some reservations, however, which lead me to prefer the approach which I have reviewed in these reasons, involving three main elements rather than two. To take the adverse effects discrimination example again, there may be cases where a law which applies identically to all fails to take into account the claimant's different traits or circumstances. It does not infringe the claimant's human dignity in so doing. In such cases, there could be said to be substantively differential treatment between the claimant and others because the law has a meaningfully different effect upon the claimant, without there being discrimination for the purpose of Section 15.1. Thus, by challenging the formal structure of the analysis under Section 15.1, from that expressed in the previous jurisprudence, the alternative approach referred to above might detract in practice from the importance placed by courts upon contextual factors and the purpose of Section 15.1. I believe it is easier and more effective for a court to apply an approach which distinguishes conceptually between differential treatment on the one hand and the discriminatory quality of that differential treatment on the other. Accordingly, I have continued this court's practice of articulating Section 15.1 analysis as having three distinct elements which have been reviewed in these reasons. At the same time, I do not disagree with the idea that the concept of substantive inequality could be defined in terms of its discriminatory purpose or effect, nor do I mean to suggest that a court which articulated its analysis using a different structure would err in law simply by doing that, provided it addressed itself properly and thoroughly to the purpose of Section 15.1 and the relevant contextual factors. Subpart E, Summary of Guidelines. Before moving on to apply the principles that I have just discussed to the facts of the case, I believe it would be useful to summarize some of the main guidelines for analysis under Section 15.1 to be derived from the jurisprudence of this court as reviewed in these reasons. As I have stated above, these guidelines should not be seen as a strict test, but rather should be understood as points of reference for a court that is called upon to decide whether a claimant's right to equality without discrimination under the Charter has been infringed. Inevitably, the guidelines summarized here will need to be supplemented in practice by the explanation of these guidelines in these reasons and those of previous cases, and by a full appreciation of the context surrounding the specific Section 15.1 claim at issue. It goes without saying that as our Section 15 jurisprudence evolves, it may well be that further elaborations and modifications will emerge. General approach. It is inappropriate to attempt to confine analysis under Section 15.1 of the Charter to a fixed and limited formula. A purposive and contextual approach to discrimination analysis is to be preferred, in order to permit the realization of the strong remedial purpose of the equality guarantee and to avoid the pitfalls of a formalistic or mechanical approach. The approach adopted and regularly applied by this Court to the interpretation of Section 15.1 focuses upon three central issues: whether a law imposes differential treatment between the claimant and others in purpose or effect, whether one or more enumerated or analogous grounds of discrimination are the basis for the differential treatment, and whether the law in question has a purpose or effect that is discriminatory within the meaning of the equality guarantee. The first issue is concerned with the question of whether the law causes differential treatment. The second and third issues are concerned with whether the differential treatment constitutes discrimination in the substantive sense intended by Section 15.1. Accordingly, a court that is called upon to determine a discrimination claim under Section 15.1 should make the following three broad inquiries. Does the impugned law draw a formal distinction between the claimant and others on the basis of one or more personal characteristics, or fail to take into account the claimant's already disadvantaged position within Canadian society, resulting in substantively differential treatment between the claimant and others on the basis of one or more personal characteristics? Is the claimant subject to differential treatment based on one or more enumerated and analogous grounds? And does the differential treatment discriminate by imposing a burden upon or withholding a benefit from the claimant in a manner which reflects the stereotypical application of presumed group or personal characteristics, or which otherwise has the effect of perpetrating or promoting the view that the individual is less capable or worthy of recognition or value as a human being or as a member of Canadian society, equally deserving of concern, respect, and consideration? In general terms, the purpose of Section 15.1 is to prevent the violation of essential human dignity and freedom through the imposition of disadvantage, stereotyping, or political or social prejudice, and to promote a society in which all persons enjoy equal recognition at law as human beings or as members of Canadian society, equally capable and equally deserving of concern, respect, and consideration. The existence of a conflict between the purpose or effect of an impugned law and the purpose of Section 15.1 is essential in order to found a discrimination claim. The determination of whether such a conflict exists is to be made through an analysis of the full context surrounding the claim and claimant. The equality guarantee is a comparative concept which ultimately requires a court to establish one or more relevant comparators. The claimant generally chooses the person, group, or groups with whom he or she wishes to be compared for the purpose of the discrimination inquiry. However, where the claimant's characterization of the comparison is insufficient, a court may, within the scope of the ground or grounds pleaded, refine the comparison presented by the claimant where warranted. Locating the relevant comparison group requires an examination of the subject matter of the legislation and its effects, as well as a full appreciation of the context. The contextual factors which determine whether legislation has the effect of determining a claimant's dignity must be constructed and examined from the perspective of the claimant. The focus of the inquiry is both subjective and objective. The relevant point of view is that of the reasonable person in circumstances similar to those of the claimant, who takes into account the contextual factors relevant to the claim. There is a variety of factors which may be referred to by Section 15.1 claimants in order to demonstrate that legislation demeans his or her dignity. The list of factors is not closed. Guidance as to these factors may be found in the jurisprudence of this court and by analogy to recognized factors. Some important contextual factors influencing the determination of whether Section 15.1 has been infringed are, among others, pre-existing disadvantage, stereotyping, prejudice, or vulnerability experienced by the individual or group at issue. The effects of a law as they relate to the important purpose of Section 15.1 in protecting individuals or groups who are vulnerable, disadvantaged, or members of a discrete and insular minority group should always be a central consideration. Although the claimant's association with a historically more advantaged or disadvantaged group or groups is not per se determinative of an infringement, the existence of these pre-existing factors will favor a finding that Section 15.1 has been infringed. The correspondence or lack thereof between the ground or grounds on which the claim is based and the actual need, capacity, or circumstances of the claimant or others. Although the mere fact that the impugned legislation takes into account the claimant's traits or circumstances will not necessarily be sufficient to defeat a Section 15.1 claim, it will generally be more difficult to establish discrimination to the extent that the law takes into account the claimant's actual situation in a manner that respects his or her value as a human being or member of Canadian society, and less difficult to do so where the law fails to take into account the claimant's actual situation. The ameliorative purpose or effects of the impugned law upon a more disadvantaged person or group in society. An ameliorative purpose or effect which accords with the purpose of Section 15.1 of the Charter will likely not violate the human dignity of more advantaged individuals, where the exclusion of these more advantaged individuals largely corresponds to the greater need or the different circumstances experienced by the disadvantaged group being targeted by the legislation. This factor is more relevant when the Section 15.1 claim is brought by a more advantaged member of society. The nature and scope of the interest affected by the impugned law. The more severe and localized the consequences of the legislation for the affected group, the more likely that the differential treatment is responsible for these consequences is discriminatory within the meaning of the section. Although the Section 15.1 claimant bears the onus of establishing an infringement of his or her equality rights in a purposive sense through the reference to one or more contextual factors, it is not necessarily the case that the claimant must adduce evidence in order to show a violation of human dignity or freedom. Frequently, where differential treatment is based on one or more enumerated or analogous grounds, this will be sufficient to found an infringement of Section 15.1 in the sense that it will be evident on the basis of judicial notice and logical reasoning that the distinction is discriminatory within the meaning of the provision. Subpart F. Application to the case at bar. Differential treatment. The preliminary issue in this case is whether the questioned law draws a distinction on the basis of one or more personal characteristics between the claimant and some other person or group of persons, resulting in unequal treatment. As discussed herein, this stage of the inquiry is not concerned with whether the distinction in treatment constitutes discrimination. Moreover, unlike Eldridge and Eaton, there is no question in this case of the impugned legislation applying without distinction to all persons, and in so doing, failing to take into account an individual or a group's already disadvantaged position within Canadian society. The CPP grants benefits to surviving spouses over the age of 35 immediately following the death of the contributor. However, these benefits are not available to able-bodied spouses without dependent children who are less than 35 years of age at the time of the death of the contributor, until they reach age 65 or unless they should become disabled in the interim. In addition, while those over age 45 are entitled to receive the benefits at the full rate, those between the ages of 35 and 45 receive a reduced sum. Thus, as a result of the ages specified under the CPP, a clear distinction is drawn between claimants over and under age 35, and also between claimants who are over age 45 and those between the ages of 35 and 45. In my view, both the delay in the receipt of benefits and the reduced entitlement to benefits constitute a denial of equal benefit of the law under the first step of the equality analysis. Distinction on the basis of enumerated or analogous grounds. Age is one of the enumerated grounds of discrimination in Section 15.1 of the Charter. The appellant alleges that she was rendered ineligible for survivor's benefits by virtue of her age and that its use as a distinguishing criterion was discriminatory. The appellant does not base her discrimination claim upon any ground other than that of age. In answer, the respondent contends that, although age is a factor in determining eligibility, it cannot be said that the appellant was ineligible solely because of this factor. Rather, the respondent argues that entitlement under Section 44(1)(d) of the CPP depends on the interplay of three factors included therein, namely age, disability, and responsibility for dependent children. This was a position adopted by the Pension Appeals Board. With respect, I cannot accept this view. In my opinion, it does not follow from the fact that any one of several criteria, including age, might determine entitlement to a survivor's pension, that the legislation does not draw a distinction on the basis of age. As an able-bodied woman without children, the appellant does not suggest that the CPP discriminates by denying her equal benefits as compared to surviving spouses who have disabilities or dependent children. The appellant submits that the issue in dispute is whether age is properly included among the factors which determine eligibility for survivor's benefits and the amount that is provided. Had the appellant been able-bodied without dependent children and over 45 at the time of her spouse's death, she would have been immediately entitled to receive full benefits. However, as an able-bodied childless woman who was 30 years of age at the time of her spouse's death, she is denied any benefit until she reaches age 65, provided she does not subsequently become disabled. Similarly, for surviving spouses aged 35 to 45, it is their age alone that serves to reduce the amount of benefits they receive as compared to those over age 45. In my view, the survivor's pension provisions of the CPP clearly draw distinctions on the basis of the enumerated ground of age. In any event, even if, as the respondent argues, entitlement under Section 44(1)(d) of the CPP were dependent upon the interplay of age, disability, and parental status, this interplay would not preclude the appellant from establishing that a distinction had been drawn on one or more of the grounds in Section 15(1) of the Charter. As stated above, it is open to a claimant to articulate a discrimination claim on no more than one of the enumerated and analogous grounds. Such an approach to the grounds of discrimination accords with the essential purposive and contextual nature of equality analysis under Section 15(1) of the Charter. Where a party brings a discrimination claim on the basis of a newly postulated analogous ground, or on the basis of a combination of different grounds, this part of the discrimination inquiry must focus upon the issues of whether and why a ground or confluence of grounds is analogous to those listed in Section 15(1). This determination is made on the basis of a complete analysis of the purpose of Section 15(1), the nature and situation of the individual or group at issue, and the social, political, and legal history of Canadian society's treatment of that group. A ground or grounds will not be considered analogous under Section 15(1) unless it can be shown that differential treatment premised on the ground or grounds has the potential to bring into play human dignity. If the court determines that recognition of a ground or confluence of grounds as analogous would serve to advance the fundamental purpose of Section 15(1), the ground or grounds will then be so recognized. There is no reason in principle, therefore, why a discrimination claim positing an intersection of grounds cannot be understood as analogous to, or as a synthesis of, the grounds listed in Section 15(1). In the present case, if the CPP had based entitlement on a combination of factors, the appellant would still have been able to establish the requisite distinction, whether on the basis of age alone or based on a combination of grounds. Discrimination. The central question in the present case is whether the age distinctions drawn by Section 44(1)(d) and 58 of the CPP impose a disadvantage upon the appellant as a younger adult in a manner which constitutes discrimination under Section 15(1) of the Charter. The appellant is asserting her claim solely on the basis of age. specifically on the basis of being an adult under the age of 45. Relatively speaking, adults under the age of 45 have not been consistently and routinely subjected to the sorts of discrimination faced by some of Canada's discrete and insular minorities. For this reason, it will be more difficult as a practical matter for this court to reason from facts to which the court may appropriately take judicial notice that the legislative distinction at issue violates the human dignity of the appellant. The appellant argues that the impugned CPP provisions infringe Section 15.1 of the Charter in both their purpose and effect. She submits that the original intent underlying the distinctions created by the sections was to provide benefits to those surviving spouses most in need, based on an assumed correlation between, among other things, increased age and one's ability to enter or re-enter the workforce following the death of a spouse. The appellant argues that this assumed correlation is faulty because, in fact, young people generally, and the appellant in particular, have difficulty in obtaining employment, and the legislation's assumptions to the contrary are based on false stereotypes regarding the advantages of youth. The appellant submits that there is no evidence establishing a direct link between a survivor's age at the time of the spouse's death and the need for benefits. She suggests that the effect of the impugned provision is to demean the dignity of adults under the age of 45 and to treat them as being less worthy than older adults by stereotyping them as being less in need. In support of her position, the appellant refers to the remarks of the Honourable Judy LaMarche, the minister responsible for the enactment of the CPP. In Parliament on November 16, 1964, Ms. LaMarche noted that the philosophy on which the CPP survivor pension is premised is that benefits should be available to those who cannot easily obtain employment. She went on to outline the eligibility criteria and reduction in benefits for those under age 45, and, as to the ineligibility of those under age 35, she stated, "Young widows in their 20s and early 30s usually have little difficulty in finding employment, and of course, many of them remarry." In reply, the respondent maintains that, although the age distinctions in the survivor's pension provisions of the CPP might initially have been based upon assumptions, the accuracy of those assumptions are also today reflected in statistical data, other legislation, and several decisions of the court. The respondent also emphasizes that the assumptions underlying the impugned CPP provisions concern not the relative immediate financial needs of surviving spouses, but their long-term financial needs. The questions to take up to the dignity-related concerns discussed above may be put in the following terms. Do the impugned CPP provisions, in purpose or effect, violate essential human dignity and freedom through the imposition of disadvantage, stereotyping, or political or social prejudice? Does the law, in purpose or effect, conform to a society in which all persons enjoy equal recognition as human beings or as members of Canadian society, equally capable and equally deserving of concern, respect, and consideration? Does the law, in purpose or effect, perpetuate the view that people under 45 are less capable or less worthy of recognition or value as human beings or as members of Canadian society? Before answering these questions, it is useful to note that although the appellant has referred this court to government reports and other sources which favor extending survivors' pensions to younger spouses on the basis that they suffer immediate financial need, she has not demonstrated that either the purpose or the effect of the impugned legislation provisions violates her human dignity in the sense discussed above, so that as to constitute discrimination. I agree with the appellant that surviving spouses of all ages are vulnerable, economically and otherwise, immediately following the death of a spouse. However, as both the appellant and respondent acknowledged in their submissions before this court, the purpose and function of the impugned CPP provisions is not to remedy the immediate financial need experienced by widows and widowers, but rather to enable older widows and widowers to meet their basic needs during the longer term. As the appellant states, reflected in the age distinctions and the survivors' pension provisions of the CPP appears to be the notion that young persons experience fewer impediments to long-term labor force participation and are generally in a better position than older persons to replace independently over the long run as a working member of Canadian society the income of a deceased spouse. It seems to me that the increasing difficulty with which one can find and maintain employment as one grows older is a matter of which the court may appropriately take judicial notice. Indeed, this court has often recognized age as a factor in the context of labor force attachment and detachment. For example, writing for the majority in McKinney, Justice Laforet stated, quote, "Barring specific skills, it is generally known that persons over 45 have more difficulty finding work than others. They do not have the flexibility of the young, a disadvantage often accentuated by the fact that the latter are frequently more recently trained in the most modern skills." Similar thoughts were expressed in Mochtinger and HOJ Industries, per Justice Iacobucci and per Justice McLaughlin, regarding the relevance of increased age to a determination of what constitutes reasonable notice of employment termination. See also Moge and Moge, per Justice McLaughlin, regarding the relevance of increased age to determination of a former spouse's abilities to support himself or herself. The answers to the questions which I posed above with respect to human dignity thus lie in part in the aim and effects of the legislation in providing long-term financial security for Canadians who lose a spouse, coupled with greater flexibility and opportunity for younger people without dependent children or disabilities to achieve long-term security absent their spouse. Yes, the law imposes a disadvantage on younger spouses in this class, but it is unlikely to be a substantive disadvantage viewed in the long term. The law on its face treats such younger people differently, but the differential treatment does not reflect or promote the notion that they are less capable or less deserving of concern, respect, and consideration when the dual perspectives of long-term security and the greater opportunity of youth are considered. Nor does the differential treatment perpetuate the view that people in this class are less capable or less worthy of recognition or value as human beings or as members of Canadian society. Given the contemporary and historical context of the differential treatment and those affected by it, the legislation does not stereotype, exclude, or devalue adults under 45. The law functions not by the device of stereotype, but by distinctions corresponding to the actual situation of individuals it affects. By being young, the appellant, a fortiori, has greater prospect of long-term income replacement. Another factor supporting the view that the impugned CPP provisions do not violate essential human dignity is the clear ameliorative purpose of the pension scheme for older surviving spouses. Older surviving spouses, like surviving spouses who are disabled or who care for dependent children, are more economically vulnerable to the long-term effects of the death of a spouse. Parliament's intent in enacting a survivor's pension scheme with benefits allocated according to age appears to have been to allocate funds to those persons whose ability to overcome need was weakest. The concern was to enhance personal dignity and freedom by ensuring a basic level of long-term financial security to persons whose personal situation makes them unable to achieve this goal, so important to life and dignity. This is a legislative purpose which accords well with the fundamental purpose of Section 15(1) of the Charter. Given that the appellant is more advantaged in a relative sense, and that the legislative distinctions in the present case largely correspond to greater long-term need and different circumstances experienced by the more disadvantaged group being targeted by the legislation, I find it difficult to perceive in the purpose or effects of the impugned legislation a violation of the appellant's dignity. The challenged legislation simply reflects the fact that people in the appellant's position are more able to overcome long-term need because of the nature of a human being's life cycle. Those who are younger when they lose a spouse are more able to replace the income lost from the death of a spouse. A reasonable person under the age of 45 who takes into account the contextual factors relevant to the claim would properly interpret the distinction created by the CPP as suggesting that younger people are more likely to find a new spouse, are more able to retain or obtain new employment, and have more time to adapt to their changed financial situation before retirement. Young people are inherently better able to initiate and maintain long-term labor force participation, and as such, the impugned CPP provisions cannot be said to impose a discriminatory disadvantage upon them. In such narrow circumstances, where legislation does not demean the dignity of those it excludes in either its purpose or its effects, it is often open to the legislature to use age as a proxy for long-term need. In referring to the existence of a correspondence between a legislative distinction in treatment and the actual situation of different individuals or groups, I do not wish to imply that legislation must always correspond perfectly with social reality in order to comply with Section 15.1 of the Charter. The determination of whether a legislative provision infringes a claimant's dignity must in every case be considered in the full context of the claim. In the present case, the appellant is more advantaged by virtue of her young age. She is challenging the validity of legislation with an egalitarian purpose and function, whose provisions correspond to a very large degree with the need and circumstances of the persons whom the legislation targets. There are no other factors suggesting that her dignity as a younger adult is demeaned by the legislation, either in its purpose or in its effects. Under these circumstances, the fact that the legislation is premised upon informed statistical generalizations which may not correspond perfectly with long-term financial need of all surviving spouses does not affect the ultimate conclusion that the legislation is consonant with human dignity and freedom of the appellant. Parliament is entitled, under these limited circumstances at least, to premise remedial legislation upon informed generalizations without running afoul of Section 15.1 of the Charter and being required to justify its position under Section 1. I emphasize, though, that under other circumstances, a more precise correspondence will undoubtedly be required in order to comply with Section 15.1. In particular, a more precise correspondence will likely be important where the individual or group which is excluded by the legislation is already disadvantaged or vulnerable within Canadian society. In conclusion, with respect to the particular circumstances of the appellant's case, I would also note that people in the position of the appellant are not completely excluded from obtaining a survivor's pension, although it is delayed until the pension reaches age 65 unless they become disabled before then. The availability of the pension to the appellant strengthens the conclusion that the law does not reflect a view of the appellant that suggests she is undeserving or less worthy as a person, only that the distribution of the benefit to her will be delayed until she is at a different point in her life cycle, when she reaches retirement age. In these circumstances, recalling the purposes of Section 15.1, I am at a loss to locate any violation of human dignity. The impugned distinctions in the present case do not stigmatize young persons, nor can they be said to perpetuate the view that surviving spouses under age 45 are less deserving of concern, respect, or consideration than others. Nor do they withhold a government benefit on the basis of stereotypical assumptions about the demographic group of which the appellant happens to be a member. I must conclude, when considered in social, political, and legal context of the claim, that the age distinctions in the CPP are not discriminatory. I find that the impugned legislative provisions do not infringe Section 15.1 of the Charter. I do not wish in any way to minimize the emotional and economic upset which affects surviving dependents when a spouse dies. My analysis herein is not meant to suggest that young people do not suffer following the death of a loved one, but only that the impugned CPP provisions are not discriminatory based on younger and older adults within the purpose and meaning of Section 15.1 of the Charter. I conclude, then, that this is one of the rare cases contemplated in Andrews, in which differential treatment based on one or more of the enumerated or analogous grounds in Section 15.1 is not discriminatory. It is important to identify such cases through a purposive analysis of Section 15.1 in order to ensure that the analysis under Section 15.1 does not become mechanistic, but rather addresses the true social, political, and legal context underlying each and every equality claim. Subpart G, Section 1 of the Charter. As I have found no violation of Section 15.1 of the Charter, it is not necessary to turn to Section 1. Part 7, Conclusions and Disposition. In the result, I would dismiss the appeal. I note that the respondent has not asked for costs. Under the circumstances, I make no order in that regard. I would thus answer the constitutional questions as follows. Do Sections 44(1)(d) and 58 of the CPP infringe on Section 15.1 of the Charter on the grounds that they discriminate against widows and widowers under the age of 45 on the basis of age? No. If so, can this infringement be demonstrably justified in a free and democratic society under Section 1 of the Charter? In view of the answer to question 1, it is not necessary to answer this question.
Thanks for the listen, friend. I hope you're able to enjoy that case and learn something new from it. Legal Listening is founded by Zach Battiston and Carly Lyons. It is hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radomile. Audio engineering by Anthony Radomile. Graphic design by Julie Lundy. Check her out online at julielundyart.com. And music done by Matt Radomile at radandkel.com. At Legal Listening, we're always open to new ideas, suggestions, and of course, guest readers. Check us out on Twitter at Legal Listening or online at legallistening.com. Legal Listening, where audio obiter is our thing. We'll catch you in the next case. Bye now.